This is the Real Estate Reckoning podcast. And we're back on the Real Estate Reckoning podcast with our special guest, DeDe Soto of Soto Law Group. We're picking up our discussion on the real estate reckoning regarding wills, estates, trusts, and probate. And so I want to get back to talking about the capital gains and deed trapped. We touched earlier on, well-meaning parents put their adult child on the deed and they think that's going to help them, but really it can backfire. So let's talk about how that can, especially from a capital gains perspective.
Perfect. Thank you, Kara. So as we mentioned before, many times to avoid probate, adults will put their adult children on the deed, right? It's their primary home. Maybe even it's a rental property. Doesn't matter. They put their adult children on the deed and they think, I don't have to have a trust. I don't have to have a will. It's just going to pass when I pass, right? Which, okay, you do avoid probate, but guess what? Like you said, it comes back to bite you because as we mentioned earlier, parents bought the property for $100,000, and this is, very practical. You could bought the property $100,000. Now today it's worth $1 million. So you have $900,000 in capital gain, right? So if you transferred and put that child on deed, they take the $100,000 as the basis. Mom or dad dies, child inherits the property. And oh, by the way, if there were other siblings, it doesn't matter. It's just that one child that's going to inherit the property. And then they go to sell it and they think, I'm going to make $900,000, right? Well, sure. Yeah, they're going to make $900,000, but they also had to pay capital gains on that $900,000 because they didn't get the step up in basis. So now the same scenario, instead of putting child on deed, what they do is they set up a revocable trust and the property goes into the revocable trust and maybe they have 2 children, right? So when they pass, the mom or dad will get a step up in basis, meaning that $100,000 property that they bought many moons ago is now worth $1 million. They pass, you get an appraisal done and you get the step up in basis, meaning that $900,000 gain, your new basis is now $1 million. So then one of the children, both of them, they sell the property, 0 capital gain. That's huge, right? And that is why you want to have a trust and have an estate plan, right? So that you get that step up in basis. And that also goes with husband and wife. If you have a revocable trust, let's say husband and wife buy it for $100,000. Then when husband or wife dies, the first spouse dies, you get a step up in basis. Right? You get a step up. So now that property is worth $1 million. Your new basis is $1 million. And then mom goes ahead and lives for another 10 years, as long as that was in their survivor's trust, not in an irrevocable trust, but a revocable trust. Then when she passes, if the property is now worth $2 million, the children will get a second step up in basis as well and 0 capital gain. So just a little bit of planning can be extremely beneficial for a tax planning as well, right? And how much money gets distributed so that, that $100,000 that could have had a $900,000 capital gain, now all of a sudden, when the second spouse dies, it's a $2 million property that gets distributed and there are 0 capital gains.
And what's the typical capital gains in California? What's the percentage on that?
Well, it depends on what income bracket you're in, right?
So is it 30%? Is it 40%?
It depends on the income bracket.
So it's very.
So spending a little bit of money
to
plan and put the appropriate trust documentation in place can save people hundreds of thousands of dollars. I mean,
Correct.
Yeah. Yes. It's a must have for sure. If you have any assets.
Right. And then that also goes with the estate tax, right? Right now, you can pass on $15 million estate tax free. Each person can pass on $15 million estate tax free. So you're balancing, the capital gain with the estate tax exemption, because if you have more than the 15 million, a couple can have 30 million. If you have more than that, then that's taxed at 40%.
Well,
so let's touch upon.
You have to know how to play the game. That's for sure.
Yeah,
exactly.
Yeah,
a little bit of planning.
Call DeDe. She could do it.
Exactly.
So let's talk about Proposition 19. It used to be
that's
called
your favorite, right?
Yeah, 60/90 was the old rule. Prop 19 came, they changed it a couple years back. So it's Proposition 19, property tax reckoning we're talking about. So how has that game been changed for inherited properties and taxes? Kind of explain the radical part of the altered tax assessment transfers when adult children inherit a primary or investment property. Give us an overview of the basis of that.
Sure. So it used to be, this is old law, right? Old law is you can file a parent-child exemption and you would be able to keep the parent's property tax basis, right? It would not get reassessed. So your primary residence, no problem. Anything over, if you had other properties, you had up to $1 million, and that's the assessed value, right? So now, fast forward, so no reassessment. Fast forward today, right? And this actually changed in 21. If parents want to leave a primary residence to their son or daughter, any of the kids, they can. However, that child has to move in. And when they move in, they have the first $1 million is not reassessed. But then after that, it's reassessed to fair market value. And if you have rental properties, no more parent-child exemption. That's over and done with. And if there's and here's where it gets tricky, right? If there are multiple beneficiaries within the trust itself actually has to take the mortgage, not the mortgage, but get a loan so that the money goes into the trust so that all of the children, if there's 3 children and one's going to move, one's going to get the house, one's going to get $1 million house, the other 2 children need to get $1 million, right? So that is part of the trust. And then they can move in and the first $1 million, there's no reassessment, right? But anything after that, it gets reassessed to fair market value. So that's the new Prop 19. That's the world we're dealing with today.
What if there's multiple properties? Is there a way to organize a trust to avoid what you just described? Is there a way to set up a trust to avoid the taxes, or you just got to pay the tax?
Well, there's various different, you can have your primary residence is your primary residence, but you can have multiple investment properties and perhaps you're going to have some LLCs and you can transfer a portion of the LLC to a child without it being reassessed. Right. So then that's not a primary residence. That could be a rental property that you set up the LLC, and as long as it's a pass through, then you're going to give 48% to a child, or maybe you're going to split the 48, they're each going to get 24%. But as soon as you pass over that 50% mark, then it would get reassessed. So if there's some long-term planning in place, yes, there's some things that you can do to limit your tax liability. How about that? You can't avoid it, but you can do different drafting to limit it and be savvy in how you're passing on your inheritance.
Well, what do they say? More whom is given, there's more responsibility. And so
correct. Yes.
This is a perfect example of that.
It is. Absolutely.
So let's shift a little bit to something that I've been encountering a lot with, there's a lot of older people that have properties to sell.
Yes.
Whether that's their primary, whether it's a long-time investment property. And I see a lot of relatives, maybe neighbors, sort of exerting, their undue influence. They seem to be very involved in decision makings regarding the property and what they should do. So just touch on that, because I think, especially in a high dollar area like Southern California that we're in, there's a lot of this. And
Yes.
So, what are some of the early red flags when there's maybe an overly helpful neighbor or relative?
Or caregiver, right?
Yeah,
You got to be careful
caregiver,
with
somebody,
caregivers.
that's, I'll go with you to the attorney's office. Oh, let me bring my contractor out to the house. And maybe, some of these owners that are older, they don't have family or they don't really have anybody watching out for them. Maybe they're estranged. So talk to us about these early red flags. How should, the situation be handled if, maybe it's a neighbor that knows about this, or maybe there are adult children, and maybe, they really don't know the true situation, what's going on. They're busy with their own lives wherever they are. What can be done, what should be done in these situations?
Yes. Well, what I see is a lot of vulnerability with older adults that live out here in California, and maybe their children don't live in California, right? They could live wherever they live and they're not having that day-to-day contact. And that's when I think the vulnerability can step in. We had a situation where someone was being taken advantage of, and I believe that kept making changes, and then all of a sudden there's this second cousin twice removed or something like that that sweeps in and is going to save the day, but in actuality they're selling off all of this poor woman's properties and taking cuts and doing naughty things, right? So a neighbor, if they had seen the situation, maybe they called Child Protective Services. I mean, some of it can be criminal. Maybe you need to report it to the police, right? If it's really extreme, if it's, extortion, or if it's embezzlement, if it's, as the transferring of the deeds, and sometimes people don't know about it. So I think when there's been changes, even us as estate planning attorneys, when we have an elderly person coming in, we have to determine capacity, right? Do they have the capacity? And not only the capacity, but are they being unduly influenced, right? Who brought them to the meeting? Is it a family member? Is it a friend? Is it the pool boy? Is it the barfly? Right? Like who brought them here? And then you can just tell, because many times they'll say, "Oh, well, I want to sit in because I know all the finances. I need to help." Well, no, you can't sit in, right? You don't have a power of attorney. I need to talk to, the man or the woman or whatever, and evaluate capacity and ask, is there any undue influence? And, if you ask someone, are you being unduly influenced? They're going to say no, more than likely. But then you ask the facts, like, well, are you seeing any of your other relatives? Oh, no, my caregiver's in charge of my phone. I don't have my phone. Well, you're like, okay, that's a red flag. When was the last time you spoke to your son or your daughter or your niece or your nephew? Where are they? Oh, I haven't spoken to them for a very long time. When, the caregiver came in, then I didn't need them, or I told them they didn't have to call me anymore, right? So there is being some undue influence, or how much are they paying this caregiver, right? That's another red flag. Is it fair and reasonable, or is the caregiver living there? Oh, the caregiver's taking a handsome salary, right? The caregiver dips into the cookie jar and takes whatever they want. So those are sort of red flags. And, I know banks, we get phone calls a lot of times where, an elderly person has gone into the bank and is withdrawing money, and the bank, they have a duty to report it as well. And I know you as realtors, you have a duty as well. So it's like you have to sort of have your radar on if there's someone that's, elderly, and are they being taken advantage of? Most definitely. And so there's the police, there's Child Protective Services. They'll come out, they'll do an investigation. Maybe someone needs to step in and act as the conservator over this person and help them. Or maybe it's just a power of attorney that they just need to have, right? So it's when you start seeing changes, you start seeing, a new roof being put on, or the landscaping, or all of a sudden, they're being whisked away somewhere. Those are all kind of red flags. It's one of those things that you just have to keep your eyes open, because it happens a lot. We had a matter where when I say the pool boy received a $2 million property, the pool boy received a $2 million property, right?
Wow.
And she was estranged from her family, and nobody wanted to do, it was like, that's, he got it. And it was not a good situation, right? But it's the way it went down.
Yeah, pool people, house caretakers, and the caregivers often sort of hit the lottery in these situations, and,
They
and,
do.
and they make their whole business, catering to people with assets that don't have anybody.
Right.
And so to your point about, well, if you see something, or maybe they need to put a power of attorney in place, if they don't have proper, trust documents set up, what can someone do? Because they're the only one with authority. I mean, I guess, you can talk to them, especially if they're coming in with the caregiver or the pool boy.
Right. Or sometimes it's a niece or a nephew, and they're trying to do right.
Yeah.
Many times the niece or the nephew, and maybe they don't have children. That's a big, kind of susceptible to undue influence. And so it's a niece or a nephew or even just a dear friend that comes in and that brings them in and can convey that, and I'm laughing, the pool boy or the barfly or
Rico Suave.
it's the bad person, right? It's the bad person that's coming in. There's a lot of really good, pool boys.
Sure. Yeah.
But it's taking a look at the circumstances and really trying to be an advocate for them. And there's a lot of really good people out there that are really trying to help the elderly, but they need to have, many times their plan was done, 30 years ago. And the people that they name, maybe they're all deceased, or, the people that were in their lives are no longer in their lives. And that's where it can become a real problem. And I know, with the realtors, you see it a lot too. You see hoarders and people having to move into a care facility and clean out the house and get it sold. And it's like, well, who's here to help them, right? Sometimes they don't have any.
And a lot of times, yeah, it's not. So any legal mechanisms, let's say, there's actions moving forward to, put the property on the market, and the person that owns the property can't even sign. Maybe they don't do DocuSign. Maybe they have capacity, but they're out of state. And, there's somebody making these decisions and hiring an agent. Now, of course, as agents, our duty, we could lose our license for listing a property without a proper listing agreement. But these things do go on. And, the first question I always ask when I sit down with anybody is, I can run a, property profile report, and I can do a lot of background research, but who has authority? And, if we have a trust, set of documents, that needs to go to escrow first, because I've
Correct.
had, adult children that were successor trustee thought they had authority to sell the house. No, they didn't, because their successor trustee and their parent was still had capacity and could, sign for things. So it's all these types of things.
They do. And if you're in a situation where somebody does not have capacity and there is not a power of attorney, there is not a trust, then that's when you're back in the probate court and you're getting a conservatorship. So you would have to get a conservatorship over that person that's cognitively impaired now, but needs to sell the property so that they can go into a facility, and someone has to come forward and get a conservatorship, right? And then you have to go to court and say, this house needs to be sold for their care. So again, it's poor planning, right? It's failure to plan. So probate, we talked a lot about it at death, but you can be in probate while you're alive. And I think that's the worst, and that's called a conservatorship, right? You're in probate, someone has to get a conservatorship because you're now cognitively impaired, dementia, Alzheimer's, whatever it may be, and you need to sell the property so you can go into a facility, but nobody can sell, like you said, you can't sell the property if the person's incapacitated, right? And so then you're going to the court and asking for a conservatorship. You get a conservatorship, someone has to come forward, and then you have to ask to have it sold as well. So there's, with realty and real estate, and here in Orange County, it's high assets. You really need to plan. I can't emphasize it. I love to educate my clients and really educate them about the need. It's not just because people say, oh, I don't care, I'm dead. Well, but what happens if you're not dead and you're incapacitated, right? That's a whole nother ball game. Don't you want to be taken care of? It's your money. You should be taken care of with your money, right?
And your house could be on the market, and you've not authorized it, and there's decisions being made. Now, of course, that will all get found out through escrow. Hopefully, if you're dealing with a reputable escrow company that's going to demand, as they should, demand documents to support this, but eventually that's going to all get found out.
Correct. Yeah. It's devastating too. It can be, right, for families, and it's just like you just need to do a little planning. A little planning goes a long way.
Absolutely.
So anything else that you want to, tell us that we should tell our audience?
What
Yes.
are some, I would say, some best tips and practices? I mean, obviously plan ahead, but what are some, mistakes you see people make even when, they come to meet with you, maybe they're not prepared. I'm sure you give them, what sort of checklist do you think do people need to have in getting all the appropriate information? And they really need to come to you with some decisions made ahead of time.
Or we can assist and walk them through. We can hold their hand so that they can make decisions. So, number one is putting co-trustees, putting, two siblings as a trustee or three siblings as a trustee. That three is usually always disaster. And parents will say, oh, well, they have to get along. Well, no, they never got along before. So I don't know why you think they're going to get along now when they're dealing with your money or dealing with you being incapacitated. So I'm not a big fan of co-trustees unless it's a professional and, a beneficiary that are mature and financially savvy. So that's key. And you always want to back up, right? We like three. We like putting your first person, primary person, second and third. And believe it or not, we've gone down to the third. So that's a big tip. You always want, the sequential. It's first, second, and third, not all serving at the same time. Disaster can happen, right? And that's for your trust, and that's also for your will, the executor, even healthcare directives, right? And I think it's really good to have a balance, right? Maybe you put someone in charge of your financial affairs, right? Your trust and your will, and you're going to put somebody else in charge of your health, because the reality is those are very different skills. Maybe you have a son or a daughter or a niece or nephew that's in the medical field. Well, they can be your healthcare agent, but they probably maybe they're not good with managing the money, right? I mean, and it's not, one or the other, but I like checks and balances. So when you're trying to decide who's going to be in charge, take a look at that and say, who is the right person, not just the eldest son or youngest daughter, whatever, who is really savvy to carry out the administration. I think that's really important. And really important too is making sure that all your assets or the appropriate assets are in the trust, or if it's a 401k or your IRAs, making sure you have beneficiaries designated, right? And if there was a spouse that passed, make sure you update those beneficiaries, because we have some matters where there's two probates going on, right? There was an IRA and it went to the surviving spouse. Then the surviving spouse died and there was no contingent beneficiary. And then that happened with the married couple. They both died. They were each other's beneficiary. And now we have two probates. So it's, updating those beneficiary forms. It's making sure, your trust and your will, making sure, and the conservatorship, you want to avoid a conservatorship like the plague, right? Who wants to have someone in charge that you have no idea? You have no idea that they're going to be managing your health, maybe managing your finances, right? And so make sure and get those documents in place. And it's the three documents. It's the Advanced Healthcare Directive, your Healthcare Power of Attorney, and your HIPAA document, right? All three of us, the privacy. So you need all three of those. They all work together. And if you're a blended family, it's, it's so important to make sure and plan, right? Because many times you hear these stories where, it was a blended family, everything went to the surviving spouse, but it's a second marriage, and the surviving spouse doesn't like their, the first spouse's, the husband's kids, and guess what? Everything went to her, and she can do whatever she wants, right? But there's ways to plan that you can protect her or him, and you can protect each other's children as well. And that's, a little bit of planning. Sometimes maybe there's three trusts. It's like I said, earlier, it's the his, hers, and then the joint trust. And then it's smooth sailing when somebody passes, right? But you want to be explicit in your terms and in your wishes. It's super important. And then we didn't even touch about this, but special needs trust and dealing with real estate with special needs kids, and making sure that that's protected as well so that they can continue to receive governmental benefits. That's probably another topic for another podcast, right?
Oh, so important. I mean, when in doubt, spell it out. Now, with these, adult children, do you ever see the provision in the, in these wills and trusts about okay, if anybody fights after I pass, then you know what? All bets are off. You're not going to get the house, or you're not going to, be able to split the proceeds equally. Cause, that's such a sore source of discussion with it, right? It's like, you can't lose what you don't have, but, there's just this sense of entitlement that people have. And it wasn't, what they did. It's what their parents did and what their parents built up. But that's a common one I hear about.
It is. Yeah. It's a no contest clause, right?
Okay.
And so it's a no contest if someone's contesting. I'm the youngest child. I'm supposed to get, 60%. My, older sibling, they only get 40%. Well, that's a contest, right? But if your oldest sibling is the one that's carrying out the trustee duties and they're not doing it correctly, that's not a no contest provision. And so, yes, the no contest provisions will carry on, but they have to be very detailed. And people have to understand that if it's a breach of fiduciary duty, that's not a no contest provision. Because sometimes they'll think, oh, they're stealing money or they're, taking a bigger share or this or that. Well, that's a breach, right? But when you're contesting 60 or 40 or 20 or 10 or whatever, that's the no contest. And then also what is really good, another little tip is, a lot of times you want your children to receive your assets, right? And then if they have kids, you want your grandchildren and your great-grandchildren, you want it to follow your bloodline. Well, there's ways to protect that so that you give it to them in trust. And then you can actually say, you know what? Sorry, son or daughter, but for my assets that I'm going to pass on to you, you have to have a prenup or a postnuptial agreement with your spouse, because many times what can happen is an asset can go to your child, but then all of a sudden they're in the middle of a divorce, and then that can become community property, right? And then it's subject to the divorce. So we like to do some asset protection so that it follows your bloodline, and we like to ask for our beneficiaries to get prenups or postnups only for the inheritance. If whatever they're making a living doing, that's fine, but we want to protect those inheritances.
This was a wealth of information. DeDe, we're going to have all of your contact information in our show notes page. But what's the best way for people to get in touch with you?
Absolutely. They can give us a call, 949-945-0059. Ask for Anita. She will set up your consultation. And if you don't have a trust or a will in place, there's no charge for that initial consultation. So, or you can also reach out. It's, thesotolawgroup.com. We've got lots of information on our website as well. And thank you so much for having me on your podcast. It's been fantastic. We could just talk for hours on all the topics. So thank you for allowing me to be a part of your show.
Thank you,
Thank
DeDe.
you. Whether you want to sell your property today on your own terms and avoid your heirs duking it out, or you've inherited real estate and need to turn that property into cash, don't wait for a crisis to force your hand. Email me, Kara Amir, and Scott Kramer at rereckoningpodcast@gmail.com today to book a strategy session and take control of your assets. And be sure to subscribe to the Real Estate Reckoning podcast on YouTube so you don't miss future episodes. Thanks for tuning in to the Real Estate Reckoning. Make sure you're subscribed and share this episode with someone who needs to hear the truth about buying and selling real estate. We will be back with more reckonings soon.